of 2025 in the matter between Sifiso Data, the first applicant, Mawilis Snendata Mjolo, the second applicant, Sandy Sontela, the third applicant, and the state as the respondent. The request for redacted particulars. Paragraph 1. Section 60, subsection 14 of the Criminal Procedure Act provides as follows. Notwithstanding anything to the contrary contained in any other law, no accused shall, for the purposes of bail proceedings, have access to any police information, record, or document relating to the offense in question, which is contained in or forms part of a police docket, including any information, record, or document which is held by the police official charged with the investigation in question, unless the prosecutor otherwise directs, provided that this subsection shall not be construed as denying an accused access to any information, record, or document to which he or she may be entitled for the purpose of his or her trial. Paragraph 2, Section 11 states that in Schedule 6, the accused shall order that the accused be detained in custody until he or she is dealt with in accordance with the law, unless the accused, having been given a reasonable opportunity to do so, adduces evidence which satisfies the court that exceptional circumstances exist, which in the interest of justice permit his or her release. Paragraph 3. In the case of State v. Mauk, 1999, Volume 2, SACR 479W, the former WLD division, the court held the accused can also have access to the police dockets to discharge the honors for exceptional circumstances in terms of Section 60(11)A, despite Section 60, subsection 14 of the Criminal Procedure Act 51 of 1977, which says otherwise. Paragraph 4, in the case of State v. Green and another, 2006, Volume 1, SACR 603 SCA, it was held that the state can be ordered to grant the defense access to the docket for relevant items. 5. In the case of State v. Lamin, State v. Data and others, State v. Dubai, State v. Kitekat, 1999, Volume 2, SCR 51 CC, the Constitutional Court held that notwithstanding Section 60, subsection 14 of the Criminal Procedure Act 51 of 1977, the prosecutor may be ordered by court and under subsection 11 to lift the bail in order to afford the arrestee the reasonable opportunity prescribed there. Subsection 14 cannot be read as sanctioning a flat refusal on the part of the prosecution to divulge information relating to pending charges. Paragraph 6, Section 35(2)(d) of the Constitution of the Republic of South Africa states the following. Everyone who is detained, every sentenced prisoner, has the right to challenge lawfulness of the detention in person before a court, and if the detention is unlawful, to be released. Paragraph 7, it is common cause that the honors rest upon the applicants in terms of bail applications which fall within the scope of Schedule 6. Any evidence which links the applicants to the alleged commission of the offense, that is any confession statements. 4. Any other relevant statements or evidence. 7.2. In essence, a copy of the entire police docket with personal particulars which are redacted. Paragraph 8. Considering the above mentioned legislation and case law, it is respectfully submitted that it will be in the interest of justice to have the particulars furnished to the defense, dated and signed at Durban on this 28th day of January 2025. That is the applicant's case, Your Worship.
Basically, statement is full of Panay, maybe in the Panay, Emma and Panay, so the Apasins of Emkhondo, the Panuchi, the Benigaz of the Panay, in Mimane, Emkhondo, the Panay, to catch the Panay. Local balance of the Panay, a Montet of the Panay, was a Matala Panagos, 60 laphana esikhathana 4 elona ukuveza laphana ukuthi ummangali laphana umuntu laphana ongummangali laphana nenhloso laphana kuba laphana icebo sakhe sebheli laphana kufanele laphana enikeze laphana imininingwane laphana equkethwe laphana emaphoyiseni laphana ehlobeni laphana necaleni elenzekile laphana noma alenzeka laphana akufanele laphana enikeze laphana leyo mininingwane ngaphandle makumshushisi-ke khona laphana akuvezayo laphana uyaveza futhi laphana laphana ngamuntu futhi okusigaba 6 laphana esikhathana 11 laphana uyashula uma icala laphana liku-schedule 6 laphana uyashumbisa laphana ukuthi kufanele laphana-ke abamangale laphana begcinwe ngaphakathi laphana-ke ey'tokisini laphana ukuze icala lize kuphele laphana-ke ngaphandle mawuhlaphana bazonikezwa ithuba laphana ukuthi beveze ubufakazi laphana-ke ukuthi-ke akhona amaphuzu angajwayelekile laphana-ke anokulungiswa laphana ukuthi-ke lingakhishwa-ke laphana-ke ngayo laphana-ke ibhili laphana-ke benze umzekelo ngelinye icala elenzeka phambilini laphana-ke u-state versus mawk laphana-ke lenzeka phambilini laphana-ke esho laphana-ke ukugcina ummangalelwa laphana-ke kufanele laphana ebe nayo ilungelo ukuthi akazi laphana ukuthi idoketi laphana liqukethe ini laphana ukuze laphana ezolungiselela laphana yena-ke amaphuzu-ke amasha-ke laphana-ke angajwayelekile laphana-ke wenze futhi umzekelo laphana ngelinye icala laphana-ke elenzeka futhi phambilini laphana-ke asho laphana ukuthi nayo umbuso laphana-ke unganikeza laphana-ke ummeli wenu laphana-ke okuqukethwe laphana noma idokhethi laphana-ke okubalulekile laphana ukuze laphana ezolungiselela lona-ke icala laphana-ke wenze futhi omunye umzekelo ngelinye futhi icala elenzeka phambilini laphana state esazidlamini no-state data laphana-ke elecaleke laphuma laphana-ke inkantolo enkulu laphana-ke inkantolo yomthethosisekelo laphana-ke lapho-ke ewaveza khona laphana ukuthi naye lapho waveza khona laphana ukuthi naye umeboshiwe laphana kufanele nikeze laphana-ke lona-ke ithuba laphana-ke ukuthi naye azame laphana ukuthi azi kunani laphana phakathi-ke kwidokhethi laphana-ke nanokuthi naye lokho-ke akufanele laphana kube umcilazelo laphana ukuthi naye emnqabele-ke lona-ke ukuthi naye kuqukethwe ini laphana kwidokhethi laphana wenze futhi-ke omunye uze laphana-ke wathatha laphana umzekelo laphana-ke wenzeke lapha umthethosisekelo laphana-ke okusigaba 35 usigadana-ke 2 laphana-ke ukubili laphana kuyagcana-ke wonke umuntu laphana oboshiwe noma umuntu laphana usegwetshiwe laphana-ke engayifakela laphana-ke inselelo laphana-ke ukuthi uboshwa kwakhe laphana-ke akukho emthethweni-ke ukuze akhululwe nanokuthi laphana kuyaveza laphana ukuthi bona-ke njengoba laphana-ke becela inkantolo laphana-ke ukuthi ibanikezele yona-ke imininingwane lena equkethwe lona-ke idokhethi laphana-ke imininingwane abayicelayo laphana-ke kuphela iy'tetimende zofakazi laphana-ke isitatimende futhi-ke sephoyisa-ke elanibophayo nanokuthi futhi into abayicela laphana-ke ubufakazi lobu-ke okunibandakanya-ke naleli cala lapha-ke nolaphana ikhona lapha-ke iy'tetimende enazenzayo laphana ukuthi nezivume-ke ukuthi niyenzile laphana-ke nanokuthi bafuna futhi iy'tetimende-ke ezibalulekile laphana-ke ezinobufakazi ukuthi leli cala like nalenza laphana-ke kuyasho laphana ukuthi amaphoyisa laphana benikezele lona-ke amakhophi ayo kwemininingwane lokho-ke ekhona laphana kuyasho-ke lokho-ke kubhaliwe kushicilela laphana kumthethosisekelo nasemacaleni-ke angaphambilini eyenzeka phambilini laphana-ke asho laphana ukuthi kube nokulungiswa laphana-ke ukuthi kunikezelelwe yona imininingwane noma benikezelele wena-ke ummeli wenu-ke nayo le mininingwane abayicelayo laphana isitatimende esisayinile laphana-ke ummeli wenu khona-ke lena-ke ema-aspect khona-ke ebhedeni.
Does applicant want to confirm?
Princess of Show Million Speak on my local experience. The princess confirmed the show.
Court business worship. State here is the justification of the defense worship. It's safe to say that the state is still standing on the basis of objecting to say the worship by colleague indicated worship. That's on the basis of Section 35 worship or subsection 12 of the Constitution that provides for a free and speedy trial in worship, which inter alia worship goes with the accused person having been informed of the charge in sufficient detail to undertake the worship. Worship to commence there on the basis of Section 35 to worship. it is the state belief, Your Worship, that the accused persons at this stage, their rights were read to them. They are well aware of the charges which are preferred by the state against them at this stage, Your Worship. Furthermore, Your Worship, I hear that my colleague, Your Worship, is basis of argument, Your Worship, is outlined on the basis of section 6014, Your Worship, as I believe that's the underlying factor. However, Your Worship, state would like to direct this court to the case of State versus Hugo, 1976, volume 4, essay 536, where the court provided that the heart and soul of the charge is that to inform the accused of the case that the state wants to advance against him. That is what fairness requires. Your Worship, state is quoting this case inter alia, Worship, in section 35.2, as per the argument of my colleague there. That is what the Constitution requires, Your Worship, that they get to be afforded, Your Worship, an opportunity to have access to the contents docket, Your Worship, which this goes as per their constitutional rights in terms of section 35, Your Worship. However, it is the state submissions that the state, as quoted, Your Worship, has informed the accused persons know what are the charges that are preferred against them. And furthermore, Your Worship, it is worth noting that the rights of the accused person in respect of this matter are not absolute, Your Worship. Your Worship, the defense, paragraph 7.1 indicates, Your Worship, that they request for particulars which they use the word redacted at this point, Your Worship, which is simply reduced in this point in time, Your Worship. They are looking for witness statements, they are requesting for statement of the arresting officer, evidence which links the accused person, such as confession statement or any other relevant evidence, Your Worship. Your Worship, it's safe to say that the basis of section 60, Your Worship, 14, it covers thoroughly and it provides a strict direction, Your Worship, that for bail proceedings, for bail purposes, the defense may not have access to the court, to the police docket, Your Worship. Your Worship, at this stage, the investigation is still at its early stages. If we provide witness statements, if we provide statements of an arresting officer, that is the state giving away the whole entire investigation. That is the state jeopardizing the whole entire investigation. It is the state submission, Your Worship, but this, what is requested by the defense, Your Worship, it's not relevant at this stage, Your Worship, to assist them in preparing for bail, Your Worship. It's safe to note, Your Worship, that at this stage, the state is not disputing to provide these particulars. It will do so at the right time when the matter is set for PM check, or at any stage once the investigation is finalized. But at this stage, Your Worship, based on what the defense is requesting, further like to direct the court, Your Worship, to the case of Shabalala and others versus the Attorney General of Transvaal and another, 1995, ZACC 12, 1996, Volume 1, Essay 725, where the court provided that the purpose of further particulars is to inform the accused person of the case which is to be brought against them so they can prepare their defense. At this stage, Your Worship, there is no defense that is to be prepared for, but rather, as my colleague has alluded to, Schedule 6, which simply says, Your Worship, that they rest the onus, Your Worship, not the defense, and onus to prove that there are exceptional circumstances which warrant for their release, not a defense in respect of the main case or the trial itself, Your Worship. Furthermore, Your Worship, the court indicated that in order to establish whether further particulars requested should be provided, the following test should be considered: whether the refusal will be of prejudice to the accused. Secondly, is the giving of the particulars in the interest of justice? And thirdly, is it pertinent to the point in issue? Your Worship, to commence with, it is the state submissions that at this stage, Your Worship, the refusal, as it's the state submissions that request for court, it will not be of any prejudice to the accused persons. This overlaps, Your Worship, with the second point, that the giving of the particulars, and that will not be the interest of justice, as Your Worship, the whole basis and argument of the state is that the investigation will be flawed. That they have access to what we have requested, statements of witnesses, statements of arresting officer. Your Worship, it's safe to say that they are interlinked, all these statements. The arresting officer cannot make a statement without arranging how the arrest came about, how the offense came about, the manner the offense was committed. That, Your Worship, will come from the witness statements. So even if, Your Worship, it was the statement of the arresting officer alone which was requested, Your Worship, just trying to point the picture to the court that this will not be in the interest of justice, because that statement originates from the witness statements. The witness statements informs what the arresting officer brings before this court, the statement of the arresting officer. Furthermore, Your Worship, as indicated, point 3, it says the court should be considered of is it pertinent to the points in issue. In this regard, Your Worship, the point in issue is bail. It's not trial. As I've indicated, the state, Your Worship, is not opposing to granting of the particulars. It's just a question of time at this stage. When the matter is ready, when this case is ready to be heard in court, then the state, Your Worship, will provide the copies, Your Worship. Your Worship, the case of State versus Child and another 2009 volume 1 SACR 479. At paragraph 31, it simply says that it cautions the court and provides that courts must guard against the abuse of power in terms of section 87, where the accused aims not to advance the proper administration of justice, but rather to obfuscate the issues. The state, Your Worship, is quoting this basis of section 87 because section 87 of the Criminal Procedure Act, Your Worship, it makes provision for further particulars to be provided on its own. That's, Your Worship, excluding the provision of my colleague of section 6014. It makes provision for further particulars. But at this stage, the courts are cautioned to safeguard. It is the state submission that this will not advance the proper administration of justice, Your Worship, as investigation is still ongoing. Furthermore, Your Worship, the courts are requested to assess whether adequate information has been given to the defense with regard to the following questions. Does the accused person need the information to answer to the charge? At this stage, there is no charge that the accused person needs to answer to. It is only for bail purposes. The only thing that the accused must do is to provide to the court, if possible, that there are exceptional. There is no charge that the accused person at this stage should answer to. And the second point is the same. With the refusal amount to prejudice, the state has already provided to this court, Your Worship, that this will not be in the best interest of justice. Your Worship, in closing, Your Worship, state humbly request the court to take into account the provision of section 6014, Your Worship, which provides clearly the basis, Your Worship. It says in its reading, unless the prosecutor directs otherwise. And at this stage, Your Worship, the wording, it is very clear that the prosecutor has not directed otherwise. Furthermore, Your Worship, based on my colleagues, Your Worship, which was start by my colleague, section 6014, Your Worship, the last sentence, Your Worship, provides that, provided that this subsection shall not be construed as denying an accused access to any information, record, or document which he or she may be entitled to for the purposes of his or her trial. It's again self-explanatory, self-clear. For the purposes of trial, not for bail. Your Worship, in conclusion, State request court to take into account this case of National Director of Public Prosecution versus King 2010 Volume 2 SACR 146 at paragraph 5, where the court provided that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable treatment. It is the state's submissions, Your Worship, that what the accused on the request of my preferred Worship will be tantamount to requesting for the most favorable treatment, Your Worship, before this court, as indicated, the heart and soul of the state investigation is still at its early stages. Any document, Your Worship, safe to put it, Your Worship, that there are no confessions. Perhaps my colleague, Your Worship, was not aware. There are no confessions which were done by any of the accused persons. Your Worship, the accused persons, they tendered warning statements just like any other Your Worship, accused persons. That's what was tendered. And that same warning statement, the state is well aware, Your Worship, that those are statements made by the defense, but the state will still advance a request not even for that to be provided, simply because those warning statements are part and parcel of the investigation. They are the ones that were tendered voluntarily to assist the state, guiding the state, giving leeway to the state in terms of where the investigation should head to. That also being provided may jeopardize the whole entire investigation. God please.
umshushisi lapha kade vezela inkantolo lapha ukuthi umlilo lapha vezela lapha ukuthi isicelo sesiike kade sifake lapha bona basiphinsa basifake isicelo lapha bona ngomuntu osele lapha usigaba 35 lapha oshona lapha kufanele lapha itshala lemakhepa inkantolo lisheshe lapha likhulu lapha kepha ke lapha futhi akukhulumi lapha ukuthi kufanele lapha ninikezele lapha imininingwane equkethwe docket lapha ngoba nina umelweni lapha ugcwele kakhulu lapha ngathi ifunda ikakhulu lapha kumthetho sisekelo lapha ngosigaba 35 lapha nithina wonke umuntu oboshiwe noma ngaphakathi lapha ejele file lapha ikhala lakhe likhulu ngokukhulu lapha ngokushesha lapha yena futhi kubuya futhi wathi lapha uyasho lapha umshushisa futhi nina nifundela lapha amalungelo enu umuntu osele lapha futhi nafundelo namacala lapha emthweswe wona lapha uyasho lapha umuntu lapha lomusho umuntu lapha usigaba 6 nosakana 14 lapha osho lapha lapha umbuso ubanikeze lapha imininingwane equkethwe lapha khona kwi-docket lapha uyasho ukwenze umzekelo lapha ukucala lapha lenzeka lapha lokhu state versus kuko lapha lapha umuntu eshaya lokho khona icala lapha uyasho futhi neqale lapha umbuso unikezeleke lapha wona-ke lapha umangala lapha umilweni lapha imininingwane equkethwe uma ukuthi icala lelike seliyazokhuluma ngalo suku lolo lapha uyasho lapha umthetho kuwumthetho lapha okhona umuntu osebenza lapha uyasho lapha ukuthi ngokwestatement elisenzile lapha ku-paragraph 7 lapha paragraph 1 lapha osho lapha ngicela lapha imininingwane lapha yofakazi i-statement ezofakazi lapha ifune futhi i-statement futhi ezemaphoyisa lawo anibophayo lapha uyasho lapha ukuthi futhi lapha ngakulula lapha ukuthi benikezele lapha i-statement lezi esho lapha ukuphoyisa lezi anibophayo ngoba lapha zingxenye zophenyo-ke ezi-statement lezi futhi nanizenzile i-statement lapha akukho futhi lapha i-statement inazenza lapha ukuthi nikhona lapha nanivuma khona leli cala i-statement ezaninzayo yokuthiwa kubizwa ukuthi ama-warning statement enazenzayo lapha bona lapha kuyasho lapha ekhulunywa lapha ukuthi ukhulunywa ngebhili akukhulunywa ngecala lapha ngoba bona bazokwazi khona benikezelele imininingwane equkethwe lapha kwi-docket uma icaleni-ke ngalosuvelo-ke sefanele manje kukhulunywe-ke lapha kepha manje ngoba ngisabethethini sebhili angeke lapha bekwazi ukuthi benikezelele yona imininingwane ephelele lapha ngoba lokho usuku sekuphazamisa-ke lena kuphela laphana-ke zafikele laphana-ke nakuthi kube kungenziwa futhi ukulungiswa uma kuthi futhi-ke inyathelo zafanele-ke nakuzongizuma laphana sinikezelele yona-ke lemininingwane leyikwethu laphana-ke ukuthi futhi-ke angisho kuyaveza funa kuchazeliwe amacala enabekwa wona-ke nanokuthi futhi kuphela kwenu futhi-ke akekapheli lapha futhi ashifuna ukunqaba kwabo laphana-ke nokuthi nabenikezele laphana-ke yona-ke imininingwane yekwethu laphana-ke bakuyidokhethi laphana angeke laphana-ke kwanilimaza lendawo lapho-ke ngokuthi phela kukhulunywa lapha-ke ngesicelo esebhili laphana-ke akukho okuningi okukhulunywa ngawo laphana-ke wofuna ukuthi kuphela kuyaphela laphana-ke kuyashukela ukuthi nake lapha wombuso laphana-ke futhi-ke kwezawo laphana-ke amacala laphana kusigaba sivuzeleka for laphana-ke ukuveza laphana ukuthi nina-ke okwenu ukuthi nifulele imininingwane mhlawumbe-ke sibheli-ke siyilungisele laphana mhlawumbe-ke sezokhulunywa licala-ke uphenyo usaqhubeka-ke laphana-ke ingakubona benqaba ukuthi nake benikezelele laphana-ke imininingwane laphana-ke ikwethu laphana-ke idokhethi ngoba izophazamisa-ke uphenyo.
Your Worship, in reply, I wish to bring the following to the Honorable Court. I do concede that cases that I've cited in paragraph 3, 4, and 5. First two makes reference to the accused can have access. Number 4, the state can be ordered. And paragraph 5, the Constitutional Court, the state may be ordered. That being the case, it demonstrates that the court still retains its judicial discretion whether in that specific case it can be granted or not. And then, Your Worship, one aspect my learned colleague for the state, though he addressed the court, he omitted to amplify him saying the statements will be provided just for the defense in the trial. Your Worship, in terms of State versus Matebula, it's a 2010 decision, Volume 1, SACR 55. It's a case, I think, that if this matter proceeds to bail, that all parties will be making reference to. In terms of this case, Your Worship, among other things, as my colleague says, the applicants bear on us to demonstrate the existence of exceptional circumstances. The SCA has stated that, among other things, the applicant must also demonstrate that the state case is non-existent or subject to doubt. It was on that basis, Your Worship. And Your Worship, in terms of the decision, State versus Mpula, it's from the Eastern Cape, Your Worship, 2007, Volume 2, SACR 133, Eastern Cape decision. In this matter, there was a statement amounting to a confession. The applicant made an application for bail relying on an affidavit. The presiding officer stated that with regard to the allegation he made, that the state case is non-existent, but the state will be relying on a statement obtained from him unlawfully. The magistrate said because he did not testify for the state to be afforded an opportunity to cross-examine on that aspect, the court felt that property value to be attached to that was liquid. It was on that basis, Worship, that we were requesting at least the warning statements of the accused so as to make a call in law what type of warning statements are. Worship, it's the same with the case of Matebula. In Matebula, the applicant applied for bail. I think there were 2 or 3. The applicant applied for bail, but in the affidavit averred that the state does not have a case. We suspect the state will use one of the co-accused as a witness. The presiding judicial officer in the lower court said if that allegation was made under oath and cross-examined, perhaps the property value would have gone a little bit higher. So the long story short, Your Worship, this court exercising its discretion in the previous matter where an order was made that at least the warning statements be furnished to the defense, an order was to the effect that certain names and information in the warning statements the state feels will prejudice the defense, the investigation, that information will be blocked out. So we received the warning statements with blocked out information, but at least able to make a call. Is it a type of a statement where we can advise the applicant to place reliance on the affidavits, or is the type of the warning statements that will require the applicants not to depose to an affidavit when applying for bail, attempting to discharge the honors resting on them, but to give viva voce evidence that has to be tested by the state. It is on that basis that, Your Worship, an instruction had to be obtained that this application be made. With the other statements, if the state is of the view that those statements at this stage are to be withheld. But what about the statement that the applicants themselves have made? Because when preparing for bail, they can't tell us what type of warning statements are those. Your Worship, this court would have seen in a number of cases, the state will allege that there is a warning statement. But when you read the warning statement, you realize that the statement has got certain admissions that require rebuttal from the applicant, or the statement, even though it's a warning statement, as you go through it, it satisfies all the R versus Becker requirement to be a confession. So it is on that basis, Your Worship, that in essence, we are saying they redacted, even if it means only the warning statements from the accused. And Your Worship, most importantly, the last sentence in paragraph 5, the remark by the Constitutional Court. Subsection 14 cannot be read as sanctioning a flat refusal on the part of the prosecution to divulge information relating to the pending charges. It's not an issue that charges are pending against these accused, subject to the finalization of the investigation and the matter to be set down for trial. So it is the use of the discretion that this application is intended to demonstrate that it be exercised favorably, at least in respect of the statements that would have been obtained from the applicant themselves, to fast track, truncate, and shorten the bail application proceedings.
Before you rest, advocate, what's the basis of the application? Are you proceeding in terms of what section of the criminal procedure act asking for this redacted information statement? The issue is, I'm of the belief that it should not be the primary application, but is it not an application that has to come after some processes? In short, is the application not premature? Is the application not misplaced?
It's not, Your Worship. Under normal circumstances, the defense would approach the state with the request, and then after the state has declined, it becomes apparent that the court becomes the final arbiter. Your Worship, as my learned colleague for the state has indicated, it is indeed the position that one is looking at section 60, subsection 14 of the Criminal Procedure Act. I won't reread it, Your Worship. And in the interpretation of section 60, subsection 14, you have got the cases that have punished this court with cases using can, may, still can be ordered, state may be ordered. It was on that basis, Your Worship, that we felt that when preparing for bail, for coherence and shortening of bail proceedings, probably if the state can furnish the redacted statement, at least the warning statement. But the long story short, Your Worship, to the court's question, the application is not misplaced.
You know why I'm saying I'm having that question is when you go also to your paragraph 5, it contains the case of state for suspension and law 2006 one. This is the answer. So let's see. But the issues in that application are very much pointed. They are saying what one wants. But when you go to your application, it wants anything.
That is the position. It wants everything. That is the first letter to the state. That is the statement before court. However, having had all the reasons that the state have furnished, it is on that basis that in the alternative, the submission is being made that at least in respect of the warning statements of the accused, redacted.
Now, what's the situation? Is the are the applicants now withdrawing their request as it is and amending it, or on what must the court now give a ruling? Must the court give a ruling on the request as it is, or must the court give a ruling on what?
As the court basis. The submission that we are making is Plan A, the application is to have a redacted statement on all the information that is provided in this application before court. As it always happens with all other applications, hence we end up saying further and alternative relief. It is on that further and alternative relief, Your Worship, that one is saying, should this court not be with the defense on the main, in the alternative, the defense is arguing at least for the warning statements.
But the application as it stands does not have Plan B. And if the court were to rule on what must the court do? If it rules on the existence of Plan B does not exist in the application.
Yes.
If it rules on the basis of Plan A, what are you saying about Plan B?
Your Worship, as I've already indicated, it is the rule of practice, whether in the lower court or in the high court, that there will be the main relief sought. The main relief sought has been argued, and in law, the door is not shut on the applicant to argue for the further and alternative relief. Based on that door that we feel is open, we are saying, should the court not be with us on the main relief sought, we humbly request that the court, of course, that will Your Worship, in paragraph 7.1, we are saying any other relevant statements or evidence. So we are saying we are no longer broadening it, but we are narrowing it down at least to the warning statements by the accused. But that will be in case the court is not with the applicants in respect of the main.
I think that is what brings me to what are you doing with your application? Does the court proceed with it as it stands? If the court proceeds with it as it stands, it does not have the alternative relief that we are talking about. The court's doors are then shut. You are trying perhaps to move to paragraph 7.1, any other relevant statements or evidence. But it does not point as well. When you go back to green, the decision in green,
yes,
it's pointing, it's saying, what are the hurdles? The first issue, the hurdles need to be identified. The hurdle is identified, then it's dealt with. It does not mean that when the hurdle is identified, then the relief is granted. The hurdle is identified. In green, the hurdle was identified. They wanted footage. The state indicated they want to proceed on basis of footage. And specifically, the court gave specifically get your footage because you want your footage and your footage is relevant. But how do you then argue relevance on any other statements? You need to be saying, court, this is my hurdle. But without saying, court, this is my hurdle, how do you then invite the court to then rule on a hurdle?
Your Worship, it is the exact point that I raised earlier on. That when my learned colleague for the state was replying, my learned colleague, mathematically speaking, was 100% correct in saying they bear on us to prove the exceptional circumstances. So I started by addressing the court that in so submitting, my learned colleague did not address the court in terms of the principle ordained in Matebo, that among other things, in demonstrating the exceptional circumstances, the applicant has to demonstrate that the state case is non-existent or subject to doubt. It was on that basis that we said our hurdle at this stage, if they depose to an affidavit, you discover that the warning statement that the state is referring to, in fact, in law, it is not just a warning statement, but it amounts to a confession. Then you go back to Mulapul. They haven't challenged that statement under oath. Those are the exact hurdles that the court is talking about. It was on that basis, Your Worship, that one were to say should the court not be with the defense on the main, the court to be respectfully be implored to look at the alternative, the further and alternative relief.
But your further and alternative relief argument is contained in the argument, but it's not contained in the application. What does the court do with the application? Does the court then say, you want to proceed on the basis of the document? And I have the document before.
That is correct.
But now are you saying court leave the document and consider only argument?
Not at all, Your Worship.
No.
It's like the state, Your Worship. The state,
maybe, sorry to disturb you. The issue is, if I have the document, I want to know if you want me to rely on it. If I rely on it, it does not have your further and alternative. It does not have your pointed headings. Your argument deals about those, but your documents do not contain say. Now, if I give a ruling, do I give a ruling based on the application, the document, or do I disregard the document? Because the document does not have the further and alternative relief. That's why I was asking, do you withdraw this and bring another one? Because State versus Green, I think you are on point on that one, but identify something, then tell the court this something is a hurdle because of this risk.
As the court places. My understanding was these proceedings are sui generis. Sui generis in the sense that there is an application, there are submissions that are being made. Otherwise, if there was a religious strict adherence to motion proceedings rules, we wouldn't have argued the matter without the state filing the notice to oppose, filing the answering affidavit. The state hasn't presented the opposing papers, the answering papers. The state has only made submissions. Having made those submissions, Your Worship, my respectful submission is those submissions by the state cannot be ignored on the basis that the state has not filed the opposition papers. What is good for the goose is good for the gander. So if one horizontalizes that principle, the same with the defense. The defense has filed the application, has made submissions. Does it then mean that the court must consider only the papers before court and not consider the submissions that have been made in support of the application in support of the application? That is where we are. It is in the submissions, in support of the application, where the defense is amplifying the hurdle, that it's about the decision, whether we go affidavit or we go viva voce, which we need to discuss with the state that if that is the case, we've got 3 accused, we have to look at the possible duration of the bail application.
I understand. But now when you amplify on the alternative relief, that then departs from the document.
Not at all.
But you may have a look at the document. It does not have what you're saying. Or you have a copy. It does not have what you're saying. Go to your relief. Your relief does not go to what you are arguing as the alternative relief. In fact, statements by the arresting officer, in fact, I think it's so much departing from your document in that you are talking now about the statements of the applicant. But there is no reference to the applicant's statements in your document. That's why I'm saying, do you get back your document and say, give what is pointed, or get back the document, court rely on our arguments, because our document does not have what we are arguing we should give. The document is not having what we are arguing you should consider. It's specific. You are saying statements. That's now their one statement. But there is nothing about statements of the applicants as a relief. or anywhere in your documents?
Your Worship, when I heard the state correctly, in its reply, the state indicated that what evidence they are having, and then the state concluded by saying they don't have a confession, by pointing out, but a warning statement with details. That's where the problem starts.
I'm not sure if they said details or anything, but
That is exactly what they said to you. They said with the details that is helping the state to follow up the investigation.
Thank you. You stated something? I see
That is all. That is all.
Lapha-ke kade isho laphana-ke umlilweni laphana kuyaphenduleka khona lapha-ke lokhu kuvezwe laphana-ke ngumfundisi laphana ukuthi na-ke amakhesi emacaleni aveziwe laphana-ke veziwe laphana paragraph 3 no-paragraph 4 no-paragraph 5 laphana-ke isitatimende esifungelo abasinikezele-ke inkantolo laphana-ke ukuthi inkantolo laphana-ke ingayalela laphana-ke umbuso ukuthi unikezele laphana-ke yona-ke imininingwane equkethwe iyona-ke laphana-ke idokhethi laphana-ke vezile futhi laphana-ke ngokuthi na-ke umshushisi laphana-ke uhlulekile laphana ukuveza laphana ukuthi na-ke ecaleni abalivezile lika-state likaSmathebula lesinqumo saphuma ngo-2010 laphana-ke kwakuyisinqumo esuka khona laphana-ke inkantolo yomthethosisekelo laphana-ke iyayiveza laphana-ke ukuthi vele kungumthetho isicelo sebhili-ke bazogxila kakhulu-ke kulelo cala lelo-ke ngesikhathi sekufake ibhili laphana phela-ke kufanele vele liveze laphana ukuthi akhona amaphuzu asemqoka angajwayelekile laphana-ke anokulungisa ukuthi-ke vele-ke nakhishwa ngayo laphana-ke ibhili kwenzile futhi-ke ngenye umzekelo icala elenzeka phambilini laphana-ke i-state business impulampula laphana-ke lelenza khona laphana-ke Eastern Cape laphana-ke kukhulunywa ngazo laphana-ke i-statement laphana-ke ukuthi nazona i-statement lezi-ke ekuthiwa lapha enizenza laphana ngenkathi niboshwe laphana-ke kuyaye kube khona laphana egcinile khona kuzo-statement laphana kube khona uvuma icala lemakuthiwa-ke kwezo-statement lezo-statement khona-ke zifakelwe iy'nselele laphana uma ukuthi-ke senifaka sona-ke isicelo sebhili laphana-ke into ezenza laphana ukuthi-ke bona-ke ngoba sefuna manje uma ukuthi-ke lezi statement abayicelayo laphana zifaka amagama abanye abantu mhlawumbe ziqukethe laphana-ke imininingwane lena-ke ezophazamisa-ke uphenyo ukuceda-ke lezi statement lezi-ke benganikezwa-ke bona-ke kepha benikezwe lezi statement lezi-ke ezingeke zifake amagama abantu futhi engeke mhlawumbe ziphazamise-ke lona-ke uphenyo laphana-ke uyahluthina-ke bona ekhonisako-ke bona bafake ukuthi bacela zonke izi-statement laphana-ke nkathi laphana seshilo-ke lapho ukuthi-ke umbuso usukuvezile laphana ukuthi uphenyo laphana zizophazamisa uphenyo i-statement siyacela ukuthi inkantolo lezi statement lezi-ke ngenkathi niboshwa laphana-ke benike ukuthi abantu sayicala-ke nasenibhala sezo-statement kuthiwa ama-warning statement ucela izo statement leso-ke laphana-ke ukuthi benikezele sona-ke futhi sekuyingxenye-ke ikaPNB wena-ke ukuthi ngifuna-ke lezo statement lezo khathi niboshwa-ke laphana kuyafunakele ngoba-ke sekuvezile umshisi lapho ukuthi-ke akaphili uphenyo laphana-ke ngicela lezi statement lapha futhi zona lezo statement lezo zikhona ukuthi niyayibhala i-statement nasekunyazo laphana ngigcina-ke nivuma lona-ke icala-ke yingakho-ke ngifuna-ke leyo mninyanto kuyahluthina-ke vele bona i-statement lesi-ke ngokwama-document akhona lapha-ke bona kuyahlukahlukana lapha kulethe laphana i-statement lapha kwi-statement ezestethe laphana-ke akukho lapho kuvela khona ukuthi nayo senifuna laphana-ke ne-statement senasenzayo laphana nkathini niboshwa laphana futhi nifunile laphana-ke mina nifune i-statement zobufakazi laphana-ke nandifuna futhi i-statement laphana-ke zawo laphana-ke ukupholisa nkathi niboshwe yanibopha ngathi senza i-statement laphana-ke kepha-ke lokhu kwe-statement lesi-ke ekukhulunywa ngaso ukuthi naye ngicela sona lesi-ke i-statement okukhulunywa ukuthi ngathi niboshwa naphendula nathini ngathi niboshwa lamaphoyisa-ke lezo statement sefuna zifana lapha inkantolo ithi ngale statement lesi-ke asikho akukho lokho-ke le-statement senu-ke esifungelwe enisinikezele-ke inkantolo laphana kuyashunywa leyo khona-ke akukho-ke kepha futhi-ke asikho i-statement futhi esinikezwe umbuso-ke laphana-ke esishoyo lapha inkantolo efanele-ke igxile kusona lapha ukuthi isinqumo laphana-ke yizo lena-ke elikhuluma umbuso kade uyikhuluma-ke ngoba nabo futhi-ke kucela inkantolo lapho ithathe lokho nje ukuthi nabo bayakhuluma lapha kuyizethulo abazenzela inkantolo nabo kuthatha inkantolo lapho kona lezethulo njengoba okwenzekile kumbuso nakubo futhi kucela kwenzeke laphana ukuthi le-statement lezi-ke ey'vumele kade benza izethulo nenkantolo-ke iy'thathile nazo-ke nabacela ukuthi naye bekuthe bekwenze lokho-ke secela ukuthi manje-ke inkantolo i-statement kuphela-ke enazenzayo ninaye inkathi niboshwa.
Your Worship, sorry, just to respond to my colleague, Worship, without able to leave the wrong impression with this court, Worship. state, Your Worship, is speaking out that here my colleague is under the impression that the state case is built on one statement. That's not true and correct, Your Worship. Furthermore, Your Worship, as stated the case of Tebula and Kwalima, Your Worship, it is true and correct, Your Worship, that at some stage for bail purposes, defense needs to challenge, Your Worship, I believe the linkage or the strength of the state case, Your Worship. Your Worship, it's something the state will not be hold now, Your Worship, because even at bail stage, the state needs to show to this court what are the basis of the state proposing to bail. Now, Your Worship, I'm trying to assist my colleagues, even just going to advance that the issue of warning statement, it's not what the state is relying on. If they so believe that maybe the state is building a case on the warning statement. Your Worship, as I've said, it's something that it's not, Your Worship, withheld by the state, as we need to show how are these accused persons linked. Your Worship, it's safe to say that they are linked through independent witnesses, they are linked through CCTV footage, they are linked through recovery of one of the deceased firearm, they are linked through recovery of one of the instruments being a vehicle in the commission of the offense. So it's a whole lot of linkage apart from the warning statements. What the state said in respect of the warning statements is that when they freely and voluntarily gave their warning statements, they gave more heads up, or they gave links as to what transpired or how the offense orchestrated prior to this. But in respect of them, their linkage to the offense, the state is not denying it.
Before you proceed for the state, on a simple question of the warning statements, if the applicants are asking for the warning statement, is there a problem if they be provided? If there is a problem, what could be the problem? I'm not ruling, I'm just asking for.
Yes, Your Worship, that's the state actually had jumped the gun because my colleague had not raised up, Your Worship. But it seems as if he's moving his entire application to the warning statement.
But let's leave him and see with me.
Yes, Your Worship.
What's the answer?
The answer is that the state is not comfortable providing the same warning statement as it contains confidential key evidence, Your Worship, in respect to, as I've indicated, how the offense was orchestrated or committed.
Yeah.
So it's part and parcel of what the state is following up and investigating.
But if they made their statement, what would be the problem if they get their statements, they make their statement?
Hence, Your Worship, it is simply that the defense should have found out from their clients, what is it that you told the state, Your Worship? But the state, Your Worship, it only touched on it at that time just to give a brush of it. The application was not based on that.
Yes.
The state did not, because I have to consult with the investigating officer in respect of, especially now that point in the law, Your Worship, of the warning statement. It's something that has not transpired through our consultation. It's something that I touched on just in argument, Your Worship.
And if the applicants approached state and pointed or said, we are requesting for the warning statements, would the state also not have?
At this stage,
Even.
at this stage.
And you say the basis is that it contains information, but they know this information, they gave it, it's them that gave it.
Correct. Hence, Your Worship, it is the state submission that the application in its entirety has been linked to a warning statement, which then would, I would say, it's in ambush to the state, Your Worship, in respect of that. Seemingly the defense had played A and B. The state was focusing primarily on their application of this issue.
But let's say they approach the state and say we want the statement. The state still not going to give the
I have to
statement.
consult with the investigative officer in respect of saying I cannot make that call.
Thank you.
That's
laphana-ke dependo laphana-ke umbuso laphana-ke ukuthi nake manje bona-ke umbelweni laphana-ke lisebenze laphana ukuthi nake icele laphana-ke itetimende-ke lezinye-ke nazo zayo ngathi laphana-ke liboshwe laphana-ke uyasho lapha ilungelo vele kulawo laphana-ke umbelweni lapha ukuthi nake efake inselelo laphana ukuthi nake itetimende ukuze ezobheka laphana ukuthi ngabe-ke umbuso unecala eqinile ngalo laphana ukuthi beveze izathu ukuthi kungani-ke benqabeke ngesicelo sebheki laphana-ke okunye futhi abazeza laphana-ke ukuthi nake kulezi statement lezi-ke enayezibhalayo laphana-ke nkathini boshwe laphana lezi statement lezi-ke ziveza laphana-ke izilezi eziyimfihlo laphana ukuthi nake icala elike lenzeka kanjani laphana-ke ngaphambi ukuthi kwenzeke leqhubu lakho noma mhlawumbe ukuhleleka kwalo laphana-ke laplanwa kanjani icala elike lezi statement lezi-ke ezithi-nake lezi enazizayo emapholiseni lezi-ke ebangeke ikwazi ukuthi enikezelele umeli laphana ngoba-ke kuyavela laphana ukuthi nake futhi imbandakanyisa naleli cala elike lina-ke kutholakala laphana-ke kwisibhamu-ke futhi sakhe laphana-ke umufi sithola lina nama-CCTV laphana futhi ikubona-ke futhi-ke laphana-ke nanemoto eyasebenziswayo enkathi kwenziwa lona-ke futhi-ke icala leli-ke ingakho laphana benqaba ukuthi nake benikezelele lapha umelweni ngawo laphana-ke ama-statement ezitetimende nazenzayo kahle laphana-ke kwenziwa lona-ke icala laphana kwafika ezitetimende lezi-ke futhi-ke kuyasho lapha ukuthi nazo zaphatha itetimende zikhululekile futhi-ke laphana-ke ingaphoqwe laphana-ke mina-ke akusini laphana-ke laphana-ke umbuso laphana umelweni fanele ukuze ukuthi nake kanti nina umbuso-ke namtshe ngawutshela ukuthi laphana-ke kwezitetimende laphana-ke akusiwona umbuso laphana kufanele kube wona futhi uthatha itetimende inikeze ummeli wenu laphana-ke umbeli wenu laphana-ke kuyaveza futhi laphana ukuthi kade laphana-ke ibuze lapha ukuthi mhlawumbe lezo tetimende lezi ngabe kuyinkinga mhlawumbe ngaba yinkinga manje kuthiwa benikezelekele naye lapha basho ukuthi naye bona ngeke bekwazi nathi umbuso laphana-ke ube kahle lapha ngisho eninikeze lezi tetimende ngoba zikhothi imininingwane laphana-ke eyimfihlo laphana-ke enzima laphana-ke nanokuthi futhi icala lelike lahleleke kanjani-ke ingakho benqaba ngisefike umbuso unikezeleke nanokuthi futhi phela ummeli wenu laphana into sabo kade wesicela lapho ukuthi benikezele yonke imininingwane hhayi lezi statement ezike inazo zayo kathi-ke kuboshwa kungabona istatement nakho sifuna silajeba nje bona sibe ne-plan B ukuthi ngoba bekusakanikezwana le mininingwane eminye kodwa bafuna kakhulukazi le mininingwane lena-ke istatement ezi enazenzayo ngenkathi laphana-ke niboshwa.
Before the first moves on to the ruling production.
Just one aspect to it, as my learned colleague has stated, that we can take instructions on what the applicant said to the police. I thought I had amplified that in my address that once you look at it as a lawyer and as a layman, you are able to pigeonhole it that, even though it's a holding statement, but it's an admission, it's a confession, which goes to the direction that at the end of the day one must. That's all.
And after you have indicated that you still feel the application is not misplaced. I mean, if you talk about now the statement that may perhaps morph into an admission to a confession, does it not perhaps now go deeper to say admissibility aspect? And when we get to admissibility aspect, then it might be a problem because this court is not seized with that function to deal with, say, but with the preliminary aspect only.
The court is having a finger firmly on the pulse, 100% right. But in terms of Mpula, the accused during the bail application, they have to take this court into full confidence how they will challenge it in the subsequent trial. Even though at the end of the day, more often than not, the judicial presiding officer in the lower court will make an indication that pointing out the confession, I defer those to the trial. But the evidence must have come from the applicant themselves. What exactly are they saying about it? Yes.
But will the applicants now say, when the state says it's a statement, warning statement, will it be fair for the applicants to say no, it's confessions?
No.
Tell the law.
No, Your Worship, that call will not be made by the applicants, they are laymen.
No, I mean for the applicants.
But the applicant can be given an advice that even though you say you made a statement to the police, upon closer look at the statement, in the world of law, your statement is this.
And advocate, you agree with the court, the issues about the alternative relief are not pointed for the court.
Yes, for the reason that I proffered initially, that yes, these proceedings are sui generis, even the state, no adverse submissions was made against the state because one understands the law courts are as busy as any other courts in the country. One to stick to the one will at some point, So, but those submissions, I can't argue that, Your Worship, because the state has not complied with the motion proceedings rules.
Because we are not strictly on motion
proceedings are sui generis. So if one accepts that, immediately one accepts that, then it becomes a problem why one would not accept it. That over and above the application, there are submissions that also have to be put in a court within which the application is being considered.
But even so, does the advocate not agree with the court that their alternative relief is not existent in the application? If the advocate doesn't want to answer, I would not have any problem.
The answer is as I've stated, that if the state, the submissions cannot be ignored by virtue of the fact that the state has not complied with the motion court rules. And one considers that, assess that the submissions by the defense, both the applications and the submissions that were made. So it cannot be that that aspect be cherry picked as adversely.
Advocate, I don't think I'll get the answer today to this one, but I'll try again. Advocate, your documents do not provide the alternative relief that the advocate is arguing about. They don't have.
I fully agree with the court.
Thank you.
That's the court.
And after having said that, advocate, if the court were to rule, on what must the court rule? Must it rule on what is not there on the document because of the answer you've given earlier, that the state had the arguments? If they are accepted, then the applicants' arguments also needs to be accepted.
It's just that I'm a bit confused.
Yes.
Whether a number of thoughts are perambulating in my mind. Whether one would consider the papers only and not the submissions by the defense, and then consider the submissions by the state not on paper only. Because it changes the picture of everything else.
The court will be guided by the advocate. Whether the advocate is amending to include that, then the court will move on the basis of point A and plan A and B. But if it's not amended, it's only on the arguments. That's not on the application, that's on the argument.
Yes, as an officer of the court, I'll have to request a short adjournment to take instructions from the. I'm a creature of the, as the court is the creature of the law. I'm also a creature of the instructions. If I may take the instructions from my instructing attorney. I apologize for the inconvenience.
Not a problem. Just do what's in the interest of justice. That's what we want.
That's the position.
I mean, that's what the court says. I love to cut out a penalty for Kalmane, Lapane, minimum, this is better. The final statement is 9 years a late cut out of the Lapano, the Lapano statement is in a certain particular we warning statement of an settlement to Kalman, who was a Lapane, I was a concern in Anapane, and a statement is again as a time of person of an
Meta will extend sanctions for it. Well, you need how much time?
Yes, 5 minutes will suffice. It seems my instructing attorney already has the instructions.
Yes. The meta stands down and the court again will be closed.
5 minutes.
You are excused.
State Court Case D1 2 2025. Stop running. So we are after 5
If I may
minutes.
be excused temporarily to
We will be back after 5 minutes.